All right. Good afternoon, everyone. My name is Brittany Mellinger. I am the Fair Housing Training and Outreach Coordinator at the Pennsylvania Human Relations Commission, and it's my pleasure to welcome you to the Fair Housing and Power Hour session on reasonable accommodations and modifications. Our Fair Housing and Power Hour series is a short introduction on fair housing topics. It's designed to be really broadly applicable for folks that are navigating the housing process, whether as a tenant, a housing provider, even a local government official or a social service provider, really anyone that's interacting in the fair housing space. We want to make sure that you all have the information you need to understand your fair housing rights and responsibilities. So let's get started. So fair housing is the right of all Pennsylvanians. At the Pennsylvania Human Relations Commission, we believe that really strongly because fair housing is so important to having access to resources, to education, to transportation, employment. It all comes back to housing. So that's why we put a really strong emphasis and focus on making sure that everyone has equal access to housing opportunities in our state. Before we get started, I want to let you know what you can anticipate today. So we are going to do a really quick overview of who the Pennsylvania Human Relations Commission is as an agency. For those of you who might be joining us for the first time today, we're going to do a brief overview of fair housing laws, talk about protected classes and discriminatory practices, and then we're really going to jump into the meat of our program today, talking about reasonable accommodations and modification requests for individuals with disabilities. We're going to talk about a couple key topics in regards to this. We're going to focus on assistance animals, hoarding, and parking requests, since those are always topics that we get questions on and are good discussion points. We're going to talk about the fair housing complaint process in the event that you would need to file a fair housing complaint or engage in that process in some way. And of course, we're going to have time to answer your fair housing questions. So as we go through this presentation, I'm going to encourage you to put comments, put questions in the chat. I will keep an eye on it, and if I can answer your questions throughout the presentation, I will do so. If not, we will have some time at the end where I can answer any questions that you have. So with that, let's get started. So the Pennsylvania Human Relations Commission is the state's leading civil rights enforcement agency. So we've got a two-part mission. Number one, we enforce Pennsylvania's non-discrimination laws. So that includes both the Pennsylvania Human Relations Act as well as the Pennsylvania Fair Educational Opportunities Act. So if you believe that you've experienced discrimination in areas under our jurisdiction, you can file a complaint. And there's going to be trained staff that are available to investigate your complaint and get to the bottom of the situation to see if there's been a violation of state law. But beyond that, we also work to promote equal opportunity for all in Pennsylvania. And we do that through a variety of partnerships, of programs. So in the housing space, we do that through our webinars, through our trainings. We've got local advisory councils throughout the state, which are local groups that connect people with information about our agency, as well as social justice ambassadors that do the same thing in other communities. So if you're interested in any of those opportunities, you can reach out to me as well. So as I mentioned, our advisory councils are a key tool for us. We also work with the Community Relations and Activities Task Force to address issues of civil tension. Local human relations commissions are key partners in addressing discrimination throughout the state. We also work through the Affirmatively Furthering Fair Housing Task Force to address issues that might restrict housing opportunity for Pennsylvanians. And we also work with housing advocacy groups. We provide a wide variety of training to audiences that might want information on fair housing topics. So housing providers, local officials, realtors, lenders, disability advocates, community members, and more. Anyone involved in the housing process can request training, and that's what I'm here for. So please reach out if you'd like any training on specific topics. We operate throughout the entire state of Pennsylvania, and we do that through 3 regional offices. So the western part of the state is covered by our Pittsburgh office. The central area of the state up into the northeast is covered by our Harrisburg office. And then the southeastern portion of the state is covered by our Philadelphia office. I work in our central office, which covers the whole state in terms of outreach and education. But the regional offices are the ones that would do the complaint investigation and work in that space. I mentioned our laws just a minute ago, and I want to do a brief overview of what they cover. So the Pennsylvania Human Relations Act covers employment, it covers housing, which is our main topic here today. It also covers commercial property and public accommodations, which would be like restaurants, public services, public spaces, and then primary and secondary education. The Pennsylvania Fair Educational Opportunities Act covers post-secondary education, so like college, trade school, certifications, things like that. All right, and now we are going to jump in to our fair housing discussion. Before we do that, I want to invite you to use your chat function and brainstorm with me. What comes to mind with fair housing? What does fair housing do? What is it? What are its goals? What does fair housing look like? You want to share any thoughts on that? Please feel free to go ahead and enter that into the chat. Thank you, Brianna. Equal opportunity to rent or own. Absolutely, that's a huge part of fair housing. Providing safe and equitable residential living. Absolutely. For areas to be accessible for individuals with disabilities. Absolutely. Thank you for sharing that. So you guys nailed it on the head. At PHRC, we talk about it in the framework of 2 goals. So goal number 1, ending housing discrimination, making sure that discrimination is not keeping anyone out of housing opportunities. Goal number 2 goes even beyond that. It talks about promoting diverse, inclusive communities through affirmatively furthering fair housing. So that's defined as taking meaningful actions in addition to combating discrimination that overcome patterns of segregation and foster inclusive communities that are free from barriers that restrict access to opportunity based on protected characteristics. So that's a little bit wonky, but in layman's terms, that means that our country has had a problematic housing history. We've had policies, we've had laws, we've had practices that have kept people from being able to live where they want to live based on their protected classes. And while we've had fair housing laws for over 50 years now, there are still patterns within our communities that keep people from having equal housing opportunities. So we need to have a targeted focus on reversing housing segregation and making sure that our communities are places where everyone can live. And how do we do that? What do our fair housing laws cover? Well, they cover the sale and rental of housing as well as housing-related transactions. When we talk about housing-related transactions, I'm talking about insurance, appraisals, lenders, really any of those industries or businesses that would surround the housing marketplace. And when we talk about the types of housing that are covered under fair housing, it's really broad. It includes apartments, single-family homes, mobile home parks, condominiums, public housing, nursing homes, dormitories, and more. Even some types of homeless shelters would be included. And when we talk about the different types of discrimination or theories of discrimination, we talk about disparate treatment and disparate impact. So disparate treatment is often what we think about when we think about discriminatory actions. So treatment that directly discriminates against a member of a protected class. So in the context of fair housing for individuals with disabilities, it could look like someone denying someone a rental unit because of their disability. I don't think you can access this unit, so therefore I'm not going to rent to you treatment. Disparate impact is a little bit less direct. So it's a policy that's neutral in its face that impacts members of protected class disproportionately. So it could look like a policy that states that to qualify for rental housing, you need to have earned income from employment. Well, that's going to have a disproportionate impact on people with disabilities because they may be less likely to have a full-time job and receive all of their income through employment. They might be more likely to be receiving benefits or getting income from other sources. Real quick overview of fair housing laws. There's 3 levels. There's the federal laws, so the Fair Housing Act of 1968, as well as the Section 504 of the Rehabilitation Act and the Americans with Disabilities Act, which provide specific protections for individuals with disabilities. At the state level, as I mentioned before, there's the Pennsylvania Human Relations Act, and then there's also local ordinances throughout the state of Pennsylvania. There's over 70 different local ordinances that provide additional protections. The federal level kind of creates that foundation. When you look at a housing metaphor, that's the foundation, that's the floor. It establishes some protected classes, and the state kind of builds on that by providing additional protected classes. And then at the local level, you can look at that as the roof, as having even more protected classes. An example of that would be source of income. That's a protected class that's available at some localities throughout Pennsylvania, but not at the state or the federal level at this point. A quick look at housing jurisdiction. When we look at what housing is covered at the federal level, it's housing providers with 4 or more properties, unless they publicly advertise vacancies or receive federal funding. They would need to have 4 or more properties to be covered by fair housing. At the state level, it's a little bit more simple, housing providers with 1 property or more. And if you believe you've experienced housing discrimination at the federal level, you have up to a year to file after the date of the last harm. And at the state level, you've got 180 days from the date of the last harm in order to be able to file. All right, and I mentioned protected classes at the various levels, and you can see that they mirror each other pretty closely, but we've got some additional protections at the state level. Federally, you've got race, color, national origin, familial status, religion, sex, and disability. And then at the state level, we add on age 40 and above, ancestry, as well as the use of guide or support animals for disability. I want to take a quick moment to further define sex as a protected class under our Act. So you didn't see sexual orientation, gender identity, LGBTQ on the list of protected classes. However, we did recently finalize regulations, which came into effect in August, that the term sex may refer to pregnancy status, childbirth status, breastfeeding status, sex assigned at birth, gender identity or expression, affectional or sexual orientation, or differences in sex development. So we use these regulations as we accept complaints, as we conduct investigations, and as we adjudicate cases. So if you believe that you have experienced discrimination in your housing on the basis of any of these definitions under the protected class of sex, you can file under the protected class of sex and have these allegations investigated. I also want to take a moment to define disability, since that's the protected class that we're going to be focusing on the most today. That's defined as a physical or mental impairment that substantially limits one or more of a person's major life activities. Some examples of this include caring for oneself, walking, seeing, hearing, speaking, breathing, learning, or working. So that's not an exhaustive list. That's just some examples. So these are things that mean that you might immediately observe someone's disability. It might be pretty evident when you first meet them or talk with them over the phone, but it might be something that's not observable. Regardless, that disability and that individual with a disability has protections under the Fair Housing Act. And the Fair Housing Act protects those who have a disability, and those who have a history of a disability, as well as those who are perceived as having a disability. So the first category, that's pretty evident. Folks who have a disability have these protections. Why do you think that someone with a history of a disability or who's perceived or regarded as having a disability would have protections as well? You can feel free to enter that into the chat if you have any thoughts on that. Why would these protections exist for folks with a history of a disability or those who are regarded as having a disability? I'm sure folks are typing away, but I want to make sure that we're using our time well as well. If someone has a history of a disability or is regarded as having a disability, they may be subject to unfair treatment from a housing provider in their housing based on that person's regard of them or their knowledge of their history. Even if they don't currently have a disability that's impacting their life, they may be subject to unfair treatment. So they do have the right to file a complaint with our agency on the basis of that. Yep, absolutely. And thank you for those comments in the chat. Absolutely. There are some disability-related exemptions. So that includes individuals who are currently using illegal drugs or controlled substances. They would be exempted from disability-related protection. So I want to be clear that this does not include folks who are in active recovery, but it does include folks who are currently using illegal substances. And individuals who pose a direct threat to the health and safety of others would be exempt from disability-related protection. Now, if a housing provider was going to deny housing to someone and cite this exemption, it should certainly be well documented. It shouldn't be speculative. This direct threat should be something that's thoroughly documented. All right, we're going to do a quick overview of discriminatory acts just to lay the groundwork, and then we're going to get into reasonable accommodations and modifications, since I am aware of the time and I want to use the bulk of our time to talk about our topic today. So these are actions that cannot be taken on the basis of someone's protected class. So a housing provider couldn't make discriminatory statements as they're advertising a unit, couldn't show a preference for individuals of specific protected classes or a preference against someone else's. There can't be discriminatory inquiries throughout the housing process. So a housing provider can't ask someone that's applying for a unit, hey, do you have a disability? They shouldn't be requesting this information because they should not be using it as they're making decisions about who to rent to. Steering, you can't steer individuals to a specific neighborhood, area of a housing complex based on their protected class. So housing providers shouldn't be steering all individuals with disabilities to the first floor or to a specific building. Folks have the right to have access to information about all available units and to make the choices that are going to meet their housing needs. A housing provider may not refuse to sell, lease, or finance housing based on protected class. Unfair appraisal, so appraisal bias is illegal, treating the value of a home differently based on who's living there. That's unfair, and that's being addressed at the federal level through the PAVE task force, Property Evaluation, Appraisal, and Valuation Equity Task Force. Predatory lending, whether that's looking at redlining, at predatory mortgages, the equal lending products, and access to financing of housing is important. So that way everyone can have an equal opportunity to purchase housing, the type of housing that's going to work for them in the area where they want to live. Discrimination in housing terms and conditions. So that could look like unequal terms in the lease, and then unequal provision of services and facilities could look like how that's carried out in practice. So the areas of a facility that someone can access, the way that lease terms are enforced. Everything has to be equal across protected classes. Sexual harassment is discriminatory, and harassment on the basis of any protected class is discriminatory. So housing providers cannot subject their tenants to harassment. Other tenants cannot harass other tenants. Even third-party vendors cannot subject residents to harassment. Everyone has the right to use and enjoy their housing and to feel comfortable and at home there. And lastly, it is discriminatory to refuse to provide reasonable accommodations and modifications in housing for individuals with disabilities. All right. So we are finally at disability-related protections. So we talk about this a lot because we get a lot of complaints on the basis of disability. Looking at our complaint data from 2021 to 2022, disability-related complaints made up the most of any type of fair housing complaints, 48% filed with our agency. And a lot of those were around reasonable accommodations and modifications. Okay. So an individual with a disability does have the right to request a reasonable accommodation or modification that's needed for them to use and enjoy their housing. So why is this necessary? Sometimes there are barriers for individuals to be able to access housing, and a reasonable accommodation or modification is needed. So we toss around these terms sometimes interchangeably, but there are specific definitions. So a reasonable modification, that's when you're looking at a structural change to the premises. And a reasonable accommodation is a change or exception or adjustment to a rule, a policy, a practice, or a service. I'd like to encourage you to pop into the chat an example of a reasonable accommodation or modification that you've encountered in your work or your life. Something that you might have requested, received a request for. See, I see a question in the chat. If you own your own home, is there a place that you can go to get modifications? Yes, there are some resources throughout the state. They kind of vary locality to locality what's available, but there are service providers that specifically work with individuals with disabilities to make those modifications. And there's also some different funding sources that either provide no or low interest loans for modifications or even grants. So I'll make sure to send out some resources when I send out the slides at the end of the presentations. That way you've got access to that information. Right, I'm seeing large print accessible documents. Absolutely, that's a great reasonable accommodation request. Prorated rent when moving in the 1st or the 30th and 31st. Sometimes a different payment date for rent is an example of a reasonable accommodation, especially for individuals with disabilities when they receive disability-related housing assistance on a specific date. Modification would be bathroom modifications to make it handicap accessible. Absolutely, we often see grab bars, tub cuts so that they can have a walk-in shower or tub in order to be able to access that bathroom. Installing ramps for walkers and wheelchairs, absolutely. Lowering countertops, modifying the cabinets. For someone that's in a wheelchair, they might need to lower that so that way they can access all of the kitchen facilities. ADA parking spaces, yep, absolutely. And are there different rules for private owners versus public housing? That is a great question that we're going to get to on our next slide. As well as permission for live-in caregiver. Absolutely, that's a great reasonable accommodation request. We'll get to these in a minute. So thank you for entering all these in the chat. Really great suggestions and examples. So it is discriminatory for a housing provider to refuse to allow a person with a disability permission to modify and pay for the changes that enable them to use their housing facilities. So a housing provider is responsible to grant permission, but it's the tenant's responsibility to pay for those changes. However, if it's public housing, if it's federally assisted housing, if it's subsidized affordable housing, that's the housing provider receives federal funds for, then it's the housing provider's responsibility to pay for the modification, not the tenant. And the housing provider may require that resident to restore the interior of the housing back to its original condition at the end of the tenancy when they move out, minus the normal wear and tear. So they don't have to require the tenant to change it back, but saying in the example of lowering the countertops, that might not be a feature that other tenants that don't have that disability would want to have. So a housing provider can say, you know what, go ahead, make that change, but when you move out, let's restore it back to its original height. There are some modifications that a tenant might make that could be really universally beneficial. So such as a grab bar in a bathroom, that could be really helpful for a variety of individuals, regardless of disability or condition. So a housing provider might want to leave that in place after that tenant's moved out. All right, and I see a comment in the chat that tenant-based housing choice voucher landlords aren't required to pay for the reasonable modifications. Yes, that's correct. So if it's housing authority that owns the housing, then yes, the housing provider would be required to pay for that. But a private landlord that just receives that voucher for the tenant's housing wouldn't be required to make that pay for that modification. So examples that we covered in the chat already: not allowing a resident to install grab bars, or not allowing a resident in a wheelchair to construct a ramp. Those would be examples of discriminatory practices. Reasonable accommodations. So it's discriminatory to refuse to make reasonable accommodations in rules, policies, practices, or services that are necessary to afford equal opportunity for an individual with a disability to use and enjoy a housing accommodation. So I think we covered all of these examples in the chat already. So not allowing a person with disability income to pay their rent on a different date than other tenants, not designating reserve parking for an individual with a disability who needs it to access their housing. And then if there would be a refusal to allow a person with a disability to have a service or support animal, even when there's no pet policy in place at the property, that would be discriminatory. We'll get into that in a little bit more detail. But first, I want to talk in generalities about the reasonable accommodation modification request. So these requests can be made at any point in the tenancy. They can be made as someone's inquiring about availability of a unit. It can be made at the lease signing, at move-in, 10 years down the line, even right before they're getting ready to move out. Doesn't matter. That's because someone's disability-related needs may change over time. They might not need that modification when they move in, but now they do. So a housing provider needs to receive and process those requests regardless of when it's given. The request can be made in writing or it can be made verbally. Doesn't matter. Each request is equally valid. Now, I strongly recommend that tenants make these requests in writing, because then there's written documentation of that request. You've got that paper trail, that documentation through your email or texts. So if there would be any issues, you could document when you made that request, what the request was and what the response was. But both writing and verbal requests are valid. Now, this request does need to be reasonable and necessary for the resident to use and enjoy the property. So there has to be a nexus or a connection between the disability and the need for the accommodation. And it needs to be reasonable, something that's achievable to use and enjoy the housing. And then the housing provider would have the responsibility to treat these residents who are making these requests fairly and to respond back in a timely manner. So HUD's guidance on this is within 10 days for a response that's reasonable. So when a housing provider is presented with a request, whether it's for a service or support animal or any other type of modification or accommodation, they should seek to establish 2 criteria. So does this person seeking the accommodation fall under the protected class of disability? And is there a disability-related need for this accommodation? If the answers to both of those criteria are yes, and the request is reasonable, what do you all think the housing provider should do? Should they grant the accommodation or not grant it? Feel free to pop that in the chat, yes or no. Or you can give me a thumbs up or a thumbs down if you think they should grant it. Yes, thank you. This isn't a trick question. Yes, they should grant the accommodation. All right. But they do have the right to request some documentation if the disability is not observable. So if this disability is immediately observable, if the housing provider can see the vision impairment, see that this individual's in a wheelchair, if it's clear that they have a disability, they shouldn't be asking for additional proof of need because that's just putting additional barriers up for this individual to get this change that they need in order to use their housing. But if it's a non-observable disability, they can ask for proof. So a lot of times that's going to look like a note from a medical provider. Doesn't have to be from the primary care physician, could be from a psychologist, could be from an optometrist, could be from a nurse practitioner, can be from any licensed medical professional that has reasonable knowledge of that individual's condition and their need for this accommodation. There are some other types of documentation that have been found to be valid as well, and that includes a determination of disability from a governmental agency. It could include a receipt of disability benefits or services, or documentation of eligibility for housing assistance. And this is coming from HUD's guidance in 2020 on assistance animals. This documentation is considered to be valid because the due diligence has already been done in getting information about this individual's condition, and they have been deemed eligible for these benefits or services or assistance because of their disability. So the housing provider doesn't need to do that additional legwork again. A question I get a lot is, well, what is reasonable? It feels like kind of a fuzzy term. And that assessment does need to happen on a case-by-case basis, but there are some factors that should be considered as a housing provider is considering whether this request is reasonable and doable. So the first factor would be the cost of the accommodation requested, particularly if it's a federally assisted housing provider that would be paying for the modification themselves. What the financial resources of the provider are, the benefits of the requested accommodation to the person who's making that request, as well as any alternatives to the accommodation that's requested. So we call that the interactive process when they're exploring any type of alternatives that might be available that might meet the disability-related needs of the individual who's making the request, if that initial request is not considered to be reasonable. Now, as they're assessing this request, there's a couple of things that a housing provider should not ask. They should not ask the nature or the severity of the disability. They shouldn't ask any questions that would lead the tenant to disclose privileged medical information. They should not ask to see any kind of medical requests or records, and they should not ask if a tenant is able to live independently.
Okay.
Person has the right to privacy and not need to disclose all of this medical information, because the housing provider does not need this in order to assess the request. Now, there are some potential reasons for denial. So the housing provider can deny the request in a couple situations. If there was documentation that's not provided, they can deny that request. If that specific request would pose direct threat to the health or safety of others, again, this cannot be speculative. It has to be documented and has to be direct, then the request could be denied. If that request would cause substantial physical damage to the property, could be denied. If there is an undue burden on the provider, or if the request would fundamentally alter the nature of the provider's operations, then that request could be denied as well. But the goal of this whole process is to meet the needs of the tenant with a disability, to help them overcome any kind of barrier to be able to access and to enjoy their housing. So if this reasonable accommodation request can't be granted, then the housing provider's responsibility is to engage in that interactive process to assess if there might be any reasonable alternatives that might meet this individual's needs. So this discussion should happen in a timely manner. Shouldn't be months on end waiting for responses. Should be a dialogue that moves along quickly. But it might take some negotiation or some conversation in order to determine an effective resolution. Could be conversation or a meeting that happens in person, could be emails back and forth. Regardless, it should be fully documented, should be saved in the housing provider's records and sent to the tenant as well. So that way there's documentation of what was discussed and what the outcome of this is. All right, are there any questions about the reasonable accommodation modification process before I move on to highlight some specific information about service and support animals? If you do have any questions, you can feel free to pop them in the chat. All right. So under the Pennsylvania Human Relations Act, it is unlawful to discriminate against individuals who use support or guide animals for disability. We know there are a lot of individuals that do need support animals to assist them throughout their daily lives and can enable individuals to live independently who would otherwise not be able to do so. But I know there can be some confusion around, well, what's a service animal? What's a support animal? What's an ESA? So I want to take a quick second to define that for you. So we're going to start with service animals. A service animal is generally trained to provide a specific task. Generally, they're going to be supporting someone with a physical disability, although that disability may or may not be obvious. Typically, a service animal is a dog, although sometimes in some situations it could be a mini horse as well. So examples of what a service animal might do include pulling a wheelchair, providing mobility support, guiding individuals who have vision impairments, as well as detecting and alerting individuals of oncoming seizures. Now, in contrast, support animal, emotional support animal, ESA, those are kind of interchangeable terms. They're less likely to have any kind of special training, but they still do serve a very valid function for an individual with a disability. The spectrum of animals that can be an ESA is broader than with a service animal. So they can be any type of common household animal, dog, cat, turtle, fish, any animal that might be commonly held in a household. And examples of what these animals can do for individuals is helping to alleviate someone's anxiety, reduce an individual's depression, help keep them calm and make them feel safe. So they are often helping people manage conditions that are not observable. They can't immediately be seen, they're not obvious, and oftentimes they're conditions that there might be some stigma around. So I know when I provide this this training to housing providers, there's often some questions about, well, is this a real need? How do I understand if, how do I understand if this individual actually has a disability and actually needs this this animal to support them, as opposed to being a pet? So there was some legislation that was passed back in 2018, the Assistance and Service Animal Integrity Act, and there's a link to that on the presentation. That does make it illegal to falsely represent that an animal is an assistance animal versus a pet or another type of animal. Now, for both ESAs and for service animals, there's no certification or licensure that is required. An animal does not need to have a vest, special tags, special ID, certificate, all of these extra paraphernalia. Sometimes service animals their owners may choose to have them wear a vest, especially when they're out in public. So that way other people aren't bothering them when they're working and doing their specific function for that individual. But it isn't a requirement. And there's unfortunately a whole host of sites that provide these additional services, these additional documentation, certifications. And unfortunately, they charge a lot of money for that and make individuals with disabilities believe that they need to have these in order to have these animals in their home, and they aren't required. All right, so I see a question in the chat. Where are service and ESA animals legally excluded from? So service animals are covered under the ADA, so they're permitted to be in public spaces. Emotional support animals are covered under fair housing laws. So those animals can be in people's homes, but they're not legally required to be allowed in public spaces like restaurants or even common areas of a housing complex. So you wouldn't necessarily need to bring your emotional support animal into a laundry room or a meal room or something like that. Whereas if it was a service animal, it would be required to allow that animal in that space. I also see a question, what if the animal is a large dog and it doesn't show any signs or wear anything that say it's a service dog? In that case, if it's out in a restaurant, in a public space, the proprietor could certainly ask, hey, is this a service animal? And go from there. If it is a service animal, it does need to be allowed in that space. But if it's an emotional support animal or a pet, would not need to be allowed to be in that space. Now, all of this can be a little confusing when you consider the websites that sell certifications and registrations, licensing documents for assistance animals, since this is really a pay-to-play industry. You pay a fee, participate in a short interview, sometimes click a survey online, and then are granted a certificate that states that this is an emotional support animal. So HUD did issue some guidance on this, and it says that in HUD's experience, such documentation from the internet is not by itself sufficient to reliably establish that an individual has a non-observable disability or disability-related need for an assistance animal. So there are healthcare providers that deliver very valid healthcare services online. There's been a lot of telehealth, particularly since the pandemic. So sometimes there will be a letter that's on letterhead from a licensed medical provider that is providing care to an individual. But these general ESA letter companies, that might not be enough to demonstrate the disability-related need for an assistance animal. And there's a link here if you want further information on assessing that documentation. I know it can be challenging, both for individuals with emotional support animals, as well as housing providers in understanding the documentation that's valid. So a housing provider can require that all individuals with animals follow state and local regulations, such as requiring licensure or vaccination as applicable. They may issue violations if this animal's conduct is violating the rules of the housing provider, if they are being aggressive, if they are harming other animals, other individuals, if they are causing all kinds of a racket. A housing provider does have the right to issue violations, and it's the animal's owner's responsibility to make sure this animal is under control and abiding by the rules of the housing provider. Additionally, if this animal is causing physical damage to the housing unit, the housing provider can hold the tenant responsible for any damages beyond normal wear and tear to the unit. Can be taken out of the security deposit at the end of the tenant's time at the housing unit. What a housing provider can't do is put limits on breeds, weight limits, on this animal requests. So a housing provider for assistance animals, including both service animals and emotional support animals. A follow-up question that I get from housing providers is, well, what about my insurance? I don't know if they're going to cover certain breeds. So they should make sure that they do any kind of, they should make sure they do their diligence before citing insurance as an undue burden, as an additional cost. They should make sure that they communicate with their insurance provider about this being an emotional support animal request under an individual's right to fair housing rights, and make sure that they clearly communicate with the insurance provider. And they should also check into other potential insurance providers before denying a request. And a housing provider may not pass along any additional expenses by charging any extra fees, any pet rent, or requiring any additional security deposits. If they would require any extra costs and fees, it would be basically like treating someone differently because of their disability, charging them more to rent a unit because of their disability, since these animals are considered to be an extension of the individual with a disability. Any questions on assistance animals before I move on to touch on to hoarding and parking? I know we're getting towards the end of our time. Feel free to enter that in the chat if you have any. But I want to briefly define hoarding for you. It's defined as a mental disorder that's marked by an obsessive need to acquire or failure to use or discard a significant amount of possessions, even if the items are worthless, hazardous, or unsanitary. There's a perceived need to save items and distress with discarding them, accumulation of possessions that congest and clutter active living spaces, clinically significant distress or impairment in social, occupational, or other areas of functioning, and it's not attributable to any other medical condition or explained by symptoms of another mental disorder. And you can see that this is straight from the DSM. It is considered to be a disability. So individuals who are suffering from hoarding do have fair housing protections, and there can be impacts of this hoarding. So it's important to for a housing provider to deal with this well. So some individual impacts can include conflict with loved ones, health and safety risks, difficulty with storing food, having people in their space. They might lose their housing or have utilities shut off because of the situation, have financial problems, mental health problems. And there's a lot of stigma around hoarding. It can accompany shame, embarrassment, defensiveness, and trauma. And there's also community level impacts as well, with the landlord, with the neighbor, hazards in the property. They might need to involve code enforcement, emergency responders, the health department, as well as senior services, child protective services, and animal protective services, depending on the specifics of the population. And this is information that was sourced from the Philadelphia Hoarding Task Force, to give credit where credit is due. I do see the question in the chat about animals and allergies, and we'll get to that in just a minute. So there's a resource on the screen here. We're not going to read through it right now, but there is a link to it. This is the clutter hoarding scale that was published by the Institute for Challenging Disorganization. It just covers the various aspects of what hoarding can impact, looking at the structure, looking at how it can impact other animals or individuals in the household, and the health and safety issues that can arise because of hoarding, as well as any kind of equipment that would be needed to address it, going from anywhere from the beginning of a hoarding situation to a pretty intensive one as well. So what does this mean from a fair housing perspective? Well, a housing provider may enforce lease terms. It's the housing provider's responsibility to make sure that the premises is safe and livable for both the tenant that's engaging in hoarding, as well as maybe other tenants that live in the building as well. So a housing provider may enforce their lease terms in order to make sure that their property is livable. And it's the resident's responsibility to ask for any help or reasonable accommodations that are needed in order to address the situation. We always recommend that as you're trying to address a hoarding situation, which can feel pretty overwhelming because there's a lot of things that need to happen, to prioritize that safety issues first before the cosmetic issues. So before you address the boxes of papers on the couch, let's make sure that you can access any emergency exits, any electrical panels, that you can access the kitchen and the bathroom, those types of things. And these are conversations that can be really helpful to have outside supports involved in, whether that's family members, whether that's social service providers, other supports in someone's life. If the tenant is willing, can include them on these discussions and communications to make sure that the tenant has support in addressing these issues. It's important to make sure that any expectations are clearly defined for both parties, state what's expected, when it's going to happen, and any outcomes of non-compliance. It's helpful to have that in writing, so that way you get clear records. And you want to make sure that as you're talking about someone's belongings and possessions, you're using neutral language. You're conscious that someone is keeping these items because they do have attachment to them. So it's important to be respectful of that. And also understand that accommodations in this area may be long-term, and it will take continued efforts to address this. Moving on to parking accommodations really briefly. A lot of multifamily housing properties already have designated handicap parking spaces because of accessibility requirements. However, this does not remove the obligation for a housing provider to make a reasonable accommodation for a tenant that needs a different parking space or one that's reserved. So this could look like a situation in which there's one or two handicap parking spaces, but they're available to anyone that needs them. So if there's a tenant with a disability that needs a parking spot that's available whenever they need to park there, they can request one that's reserved specifically for them. Or if they need it in a specific area to make sure that's close to where their entrance is to their unit, they could request a different one as well, as long as there's that connection between their disability and the disability related need for the request. So the housing provider is required to accommodate as long as the request is made and the appropriate documentation is provided. And if there are some costs, the housing provider is responsible for these costs. Wrapping up the section on reasonable accommodations and modifications, want to acknowledge that there can be impact on other residents. So sometimes a resident may voice disability-related concerns, and it's important to work through to resolve these issues in an interactive process. So for example, one resident requests an ESA, but another resident discloses that they're allergic to cat dander. Would need to work through that, making sure that accommodating one tenant's disability-related needs isn't infringing on someone else's disability related needs as well. So this can be a challenging situation to navigate. You can always call the Fair Housing line if you have questions, or you can reach out to a local fair housing agency to help you navigate this as well. But just know that if there are conflicts in these types of situations, it's important to make sure that you're dealing with actual documented needs and conditions, not speculation on what might occur. Some best practices, housing providers should make sure that they've got an established policy on these requests, make sure they document everything in writing, make sure that they're limiting information requested to just what's needed to provide this request, and allow sufficient time for documentation to be submitted, responding back in a timely manner as well within 10 days, making sure that they always engage in interactive dialogue to meet the needs of the tenant. All right. I see a question in the chat about the city and the landlord claim the reason why they want to assign the handicap parking space is because it's the main street and it will change the law. Municipalities also have a responsibility to make reasonable accommodation requests when needed. So it does have to be reasonable. But if a resident would need that designated parking, even if it's on a main street, want to submit documentation to the city to work with that team. And if you do have any issues with getting that request processed, again, call our fair housing line, call your local fair housing agency to work through that. If you have more specific questions, you can always reach out to me one-on-one. And we've got just a couple minutes left, so I want to briefly go over the complaint process. If you've done our trainings before, you may have seen a long flow chart. We're not going to go through all of that today. But if you believe you've experienced housing discrimination, you want to contact our intake team. We'll have contact information at the end of this presentation, which will get sent out. Again, you've got up to 180 days from the date of the last time to file a complaint. Fill out a housing questionnaire with information about what you've experienced and who you're filing a complaint against. And then PHRC staff will assess the complaint to see if this is something that we can investigate under state law. If this complaint is jurisdictional and timely, the intake team will help to finalize that complaint. And then the person who was filed against, the respondent, will be notified. Both parties will be asked to provide information to a neutral investigator whose responsibility is to investigate if there's a violation of our law. And ask for evidence, including documentation, maybe interviewing, holding a fact-finding conference, going on site, obtaining that evidence. And the investigator will also explore if it's possible to settle the case before finding. But if the case proceeds to a finding, two possible outcomes could be probable cause if there's enough evidence to determine probable cause of discrimination, or no probable cause if there's not enough evidence to determine probable cause. At this point, if it's probable cause, a case may be conciliated and advanced to public hearing or be filed in court, with the goal being seeking a remedy for the discrimination that occurred. And the amount of time it does take to work through this whole process can vary based on the evidence, based on how quickly both parties respond, as well as other factors. There's a variety of remedies that can be sought to address this housing discrimination. And there's also a slide here that provides some examples of recent cases regarding housing. We do take this very seriously, and there are consequences when our law is violated. You can call our additional webinars, request materials, as well as tune into our series PHRC Speaks Fair Housing in the 21st Century. You want more information on any of that, you can reach out to me via email. Now we run up to the 1 o'clock hour. I'm available if you have any additional questions. You can feel free to hang on and ask those. But if not, I'd like to thank you for joining me today on the Fair Housing and Power Hour. There's a QR code on your screen. Please pull out your phone and please take just a couple minutes to provide some feedback on what you found helpful about this presentation, what you think could be improved for the future. We really do take a look at that feedback and use it to improve our offerings. I'm going to take a quick scan back through to see if there's any questions that I missed. But if I did miss your question, I apologize, and please feel free to reach out to me via email. I'd be happy to answer any questions. All right. Well, with that, I think I'm going to close this out. Thank you again, everyone. I hope you have a great day.